So now I'd like to invite Mr. Ken Thorne to the stage. He earned his BBA in 1968 and JD in 1970 from South Methodist University. He specializes in personal injury trial law and is currently the senior partner at Thorne and Skinner Law Firm. Mr. Thorne is a very active member of his community, and we're very thankful for him being here today. I'll turn it over to Mr. Thorne. Give him a round of applause.
Thank you so much. It is an honor to be here, and I'll give a warning that GS was kind enough to invite me to the meeting in May of 2013. I can't believe it. I thought it was maybe last May. The time has gone by so fast, and for those of you who were there, I can only say repetition is valuable in learning, and I'm sorry that you'll hear pretty much the same thing again. The only change really in the law of what I'm about to talk about is that the legislature has changed what we used to call the probate code, which is the law governing the estates of deceased persons. And they've now named it the Estates Code. So we have to learn all the new sections again, and there's a lot of fine print in here. But that's really the only change. My father was a lawyer, and growing up and going through his office for years, I saw his sign up on the credenza that said, "Have you made a will?" And of course, GS asked me if I was going to bring a PowerPoint today, and my PowerPoint was going to be that little sign that I just love and I inherited from my dad. But GS, I walked off and left my PowerPoint, my only show and tell gimmick. But that sign said, "Have you made a will?" And I wondered, why do you have to tell people, remind them? But I've learned in 44 years of practicing law that getting around to estate planning and preparing wills and seeing lawyers to do that isn't easy. And I can't even update mine as frequently as I should because it's hard to get to. It's hard to make these decisions. And we have so many young people here, which is great. And when you're young, you think well, nothing will ever happen to me, and I'll never need these kinds of documents. But time shows us that we all are going to meet our end, and at the end, the process of having a will provides for the transition of ownership of our property. That's basically what a will is. It's a means of our establishing and carrying out our desire and our need to transfer title to our property. So that's a will. There are several documents that I want to touch base on the basics, the fundamentals of these documents. One of them is a will, of course. With a will, sometimes we like to include a trust that might take effect at death, at the time of our death, to hold property for the benefit of a person under certain terms and conditions for a certain period of time. In addition, we recommend consideration of other documents to take effect while we're living. The first one being what we call a statutory durable power of attorney. Many of you are familiar with power of attorney forms, but it's just a document by which we designate an agent to be able to sign for us. Another similar document is a healthcare power of attorney. And that's a document by which we designate an agent to give consent for health care. And the other document that I think is essential is we used to call it a living will, but we now call it a directive to physicians because that's the name given in the Texas Health and Safety Code from which we take that document. So as I go through these as quickly as I can, I'm going to start with that directive to physicians. But I meant to start off with something else. Seeing Ray Ann Forster give a talk here, and having the respect that I have for her and her practice as a CPA, I would want to emphasize that when you choose someone as a professional to assist you in matters like accounting, law, financial planning, that you check them out a little bit. Check out their background, make sure they have the experience and their reputation. It's best to get referrals from people who have dealt with them. And the reason that I think it's so essential is Rayanne has been in her practice for so many years, and as she pointed out, her great father, Roger Curbo, has been a CPA since 1963, and he's been in essentially the same office, 2 offices within a couple of blocks of each other, for over 50 years. So that tells you something. A person who is not honest and who doesn't do a great professional job does not last in one community for that period of time. And I think that's important in making your selection. Get someone in whom you can have trust and confidence, because you'll need it. They're a fiduciary to you. They hold you, the highest legal, ethical, moral position with respect to their dealing with your affairs. Important to get the right person. So this directive to physicians, we have a code that covers, we have all kinds of codes in law, but one of them is the Health and Safety Code, and it sets up a provision for us to designate our end-of-life decisions. Many of you are old enough to remember a litigation that was a matter of national news several years ago called the Terry Schiavo case. This was a case of a woman who had been in an accident for many years. She was in what's called a vegetative state, at least that was the argument, that she was non-responsive, and her husband advocated that her life support should be removed because she is being kept alive merely on a ventilator and feeding tube. The lady's family disagreed, and they ended up in a court case of all things over this sad situation. And the courts for years held off until finally a decision was made to allow the life support to be removed and to allow this person to be removed from this life, to die. And on autopsy, it showed that she had a very debilitated brain. She had what pathologists might call a Swiss cheese brain, holes and gaps in her brain. She had been brain dead for all these years, and they'd merely been putting the families through the horror. So the Health and Safety Code is meant to give us a way to handle a situation like that for end of life. And many of you may have dealt with this, at least thought about it. Some of you are in the healthcare professions and are familiar with the issue, or have had personal experiences in your own families where perhaps a parent or a loved one is in that shape, and you're asked, can we remove the ventilator? Can we allow this person to go or not? So with this form, this directive, which says that if I am in a situation in which my physicians declare that I'm terminal, I'm going to die, and I'm incurable, they don't have a remedy for this, and that I'm merely being kept alive on life support, that is a ventilator, that's breathing for me, and a feeding tube that's giving me my body nutrition, it's my desire to either have that life support withdrawn and allow me to die naturally, or alternatively, give me whatever medical science can offer and keep my body alive with the hope that something will happen, a miracle, and I can be brought back. And the only situations I know of a resurrection like that, bringing back a dead person, of course, was with Jesus Christ. And maybe the other situation was when Jesus told Lazarus to rise from the dead. So that might be two situations. So most people do choose the first choice. If I'm in that situation, it's certified. It's my desire to be allowed to die with whatever remaining dignity that there is in the situation, and to take my family out of the decision making. I'm making the choice myself, but it certainly can't be criticized if you have a different opinion. But without that directive to physicians, the healthcare providers are under the obligation to keep providing all the care that they can provide. So that's a directive to physicians. I wanted to say that before I get into the wills, because I may run out of time. Judge Reddy has only given me 20 minutes, and I'm used to that as a lawyer. The judge says, you've got so long, and at the end of it, in mid-sentence, when he says that's it, then I quit. So I want to talk about wills. Wills are simply instruments or documents by which we express our desire of transfer of our assets at death. A will can be a simple document. I once probated the back of an envelope in which the deceased person had written a couple of lines saying, at my death, I'll leave my estate to my wife. And that was held to be sufficient for a will. Now, we usually think of a will in a more formal way, a document that's typed up, and that's the one I recommend, of course. And as with Ray Ann, I recommend that you go to a lawyer to do this. I had a couple of situations, one right now particularly, but just within the past couple of weeks, where people downloaded their will from the internet and thought they were doing the right thing and filled in the blanks, but they didn't do it correctly, and the wills couldn't be accepted. So it ends up then there's no will if it's not properly prepared. So you can have a will that's a holographic document. Holographic being a technical term, meaning that it's all in your own handwriting, your pen, and it's signed by you. And it says, when I die, at my death, and some people say, well, in the unlikely event of my demise. Well, it's not unlikely. We are all going to be there. So at my death, I give my property to, in a certain way, however we're going to do it. All of it to my wife, all of it to my children, something, and signed. That could be sufficient for a will, a bare bones will, and it beats nothing. It beats nothing. The other way to do it is you have the typed instrument. If you have it, if any part of it is not in the person's handwriting, it's typed, it has to be a clearly expressed desire of your intent, how you want your property to go. And it has to have two witnesses who at least have to be 14 years of age, who sign the document along with and in the presence of the testator being the person making the will. That is a will. Now, when we do this in a lawyer's office, we add one more thing. We add an affidavit to the will that's notarized. An affidavit is simply a statement that's sworn to. So we add an affidavit that we call self-proving affidavit to the will that says, on this date, appeared before this notary public, the person making the will, again, the testator, and the witnesses. And they all swore that the testator declared that this was their will, and it was signed in the presence of the witnesses, and the witnesses swear to this too, and that everybody's of the correct legal minimum age, and they swear to this before the notary. With that affidavit added to the will, we don't have to have the witnesses show up in court years later after the person's died and we're in probate court. It's simply accepted. The testimony is accepted in advance. So that's the bare bones of a will. A will with respect to disposition of property can say, I make specific gifts. I give my special earrings to my favorite granddaughter. I give my golf clubs to my grandson. I give my special automobile to my somebody. Specific gifts. Or we can say, I give everything to this person. And frankly, for a married couple, a typical will simply says, I give everything to my spouse if he or she survives me. And if not, and we have children, I give it all to the children to share equally. I mean, that's your basic standard will. So that would take care of it. Now, the property that you can pass through a will is your property. When you're married, half of the property that you acquire after marriage is called community property in Texas. So each spouse owns 50-50. Each spouse owns half. You can pass your 50% to the other party. If you had property before marriage and you didn't mix it all up and commingle it, then that's also your property to pass through your will. If you inherit property, even though you're married, or you receive property in a gift, that's your separate property. It's yours to dispose of as you wish. So those are the separate property, and half of community is what you're passing through your will. You can't affect your spouse's other half. Now, for a married couple who own a home, you cannot take away your surviving spouse's right to the homestead being where you live. So the surviving spouse does have the right to live in that homestead for the balance of his or her life, so long as they choose to live there. Of course, they could abandon it and move, but they have the right to live there, even if it were your separate property. So there's a protection for the surviving spouse. One of the important features of a will, and particularly in what makes Texas unique among many states, is that we have a law that allows you to appoint an executor of the will who's called an independent executor. The executor is the personal representative that you appoint in a will to carry out the terms of the will. In Texas, if you name the person as independent, that means independent of court supervision. So they're on their own. They do have that fiduciary responsibility, that high ethical, moral, legal responsibility to the estate to carry out your wishes and follow the law, but they don't have to report to the court. They're not supervised. If you don't have an independent executor, then the court has to appoint a person to serve in that capacity, and they have to put up a bond equal to the value of the estate to ensure that they're not going to misuse their office as executor. So the executor's job is to identify the assets of your estate, to gather them up, take control, pay off the debts that are still lingering, and to then deliver the estate to the beneficiaries. That's what the executor does. And in Texas, if it's an independent executor, all that's required is that that executor files a form with the probate court. For Dallas, it's Dallas County. If you live in Tarrant County, it's in Fort Worth at the Tarrant County Probate Court, or Denton County or Collin County. The county depends upon where the deceased person lived. You file a form called an application to probate the will. Then you file the will. Within a month, you have a hearing, one court hearing, one time to go to court. It's a simple walk-through hearing of formality for the court to read the will, make sure everything is done correctly, and assuming that it's found that it was all signed correctly, then the court signs a court judgment saying it's a valid will, and that makes it effective. But until you probate the will and get that finding, the will's of no effect. You have to go through probate. So then the executor's appointed. The court clerk will give the executor a document called letters testamentary, which allows the executor to take to the bank or wherever you're going to take it to carry out the terms of the charge in the will, to gather the assets. That's the letters testamentary is the court authority. I want to touch on one thing that's important here in estate planning with respect to disposition of your estate at your death. You can create non-probate assets. An example of that is a life insurance policy. You pay premiums to a life insurance company with the contract saying that at your death, you have designated a beneficiary, and the life insurance company then will deliver the proceeds to the beneficiary. That's not part of the will. That's a non-probate asset. It goes according to the contract. When you set up an IRA or typical retirement plan, they ask you to designate a beneficiary. When you designate that beneficiary, again, it's non-probate, so that asset goes outside the will to the designated person. Many of you may be familiar with joint accounts at financial institutions, bank accounts. And when you set up the bank account, they give you a signature card, and they ask you, do you want this to be payable on death, or for shorthand, POD account? And if you say yes, and you check mark that, then when one of the persons who's a joint signer on the account dies, it's payable on death to the other person. It's a POD account. All those accounts pass directly to the beneficiary. You don't need a will for those accounts. And frankly, sometimes we find that because everything's set up this way, we don't really have to even go through probate. So there are situations. Are we done? Time? Okay. I didn't even get the power of attorney forms, but maybe you can ask me later. It's my privilege to be here. Thank you.